you have any query, you can ask madam by unmuting yourself. By then, you have to turn off your video and audio so that there is no disturbance in the session. Yes, thank you. Madam, you can start with the session.
Yes. Okay. My PPT is visible now.
No, ma'am.
No, ma'am.
Okay. I guess now it's visible, right?
Yes, ma'am.
Okay. Good morning, all. Am I audible and my PPT is visible now?
Yes, ma'am. Audible.
And PPT visible? I'll try to share my
No,
screen.
ma'am. No, no visible.
Still not visible. Oh my God.
Yes, ma'am. Now I'm visible.
Okay. Okay, so we'll start with today's session about intellectual property rights. I guess we all are aware of what intellectual property rights are and what it means in general sense, but not legally or technically. We are not much aware about these things, right? So when intellectual property rights or intellectual property, we hear this word intellectual property. What comes to our mind is some logo or any specific product or anything which we see around, right? But apart from that, there are like numerous things which come under intellectual property. So first we will see the general idea and what actual intellectual property means. So what is intellectual property? Intellectual property is an intangible creation of human mind, usually expressed or translated into tangible form that is assigned certain rights or property. Now you will say that this is such a technical definition you are telling us. But to tell you frankly, when we say word property, it is a tangible thing that we see. The property can be immovable or movable. Immovable property is land, building, or anything which we see, we can touch. Or movable property, even that property which is our bank statements or bank accounts, which we can see, which are tangible. They have their existence, right? So that is the property we usually come across with. Okay. However, there is certain properties which cannot be seen or which are invisible in nature. Normally, they are from our human mind. So when there is a creation in our human mind, we are implying our intellectual, and we are creating something. That creation is our intellectual property, that becomes our property. So that property is called intellectual property. And there are, like, decade ago, not decade, a century ago, there was no concept as a intellectual property or a intangible property. Only property which we can see in the world or in universe, we used to protect it, because the rights were developing. However, now as we have recognized this property, which is an intellectual property, which is intangible, that property needs protection. That property needs to be valued and to be preserved for future use, for our own use, and for our own benefit. Then that property is called intellectual property. And when we have rights for that intellectual property, we call it intellectual property rights, and in short it is called IPR. Okay. So whenever we own any movable property, like furniture, chair, anything, table, anything, that when we own it, we have certain rights attached to it. When we own a building or land, we have certain rights attached to it, that we can use it peacefully. We have right to enjoy it peacefully, and no one can intervene in our property. No one can intervene in uh, our rights to enjoy the peaceful enjoyment of the property. Okay. Similarly, here, when we say the intellectual property rights, it is basically we are having similar rights to our intellectual property, similar to the movable and immovable property, such as we can use it peacefully, we can reuse it, we can reproduce it, we can get benefit from it. We can not just financial benefit, but we can get benefit, not financial, not just financial benefit, but whatever benefit we want to get it from. Okay. So we can sell half of it, we can sell three-fourth of it, or anything of that sort. Okay. So best examples are when we see any unique design on website or furniture, or if we see a logo on soft drink, we immediately recognize that this is, say for example, Coca-Cola, or this is Microsoft, or any it has a unique design recognized or attached to that company or that person or that entity. And then when it is recognized by world or by other people, it becomes your right and it becomes your privilege to use that property for your own benefit or use. Okay. So that is intellectual property, and that the rights concerned with those intellectual properties are called intellectual property rights. Today we are going to see what rights we have in India, and what how it started, and how we can implement it, how we can execute it, and how we can derive benefits from it, right? So in India, as I guess generally you must be aware of this five types. One is patent, second is trademark, third is copyright, design, and geographical indications. I'm going to elaborate what these five intellectual property rights are, and how they can be used, or how they can be procured during the process. Okay. So basically, what is patent? Patent is normally you get it for the product. Trademark, you get it for the logo. Copyright, you get it for your work, for your artistic work, or written work, or whatever the unique work you have done, you have created from your intellect, you get copyright for that. Then design is simple, it is a design. Then there is a geographical indication as well, that I am going to explain in further slides. So when it all started, when this concept of intellectual property came to the mind of human, actually human only. Now we are going to see it in India, but how, when it began and how it started in the world. Because it was, even though we had our unique creations in India for thousands of years, we never thought about it, we never practiced it, we never protected it. However, the whole movement started in the world in 19th century. As you can see from the slide, that it started with Paris Convention, which held in 1883. So it was more than I guess 140 years back. So at that time, it was very raw, and there was no defined concept of intellectual property. They defined the intellectual property much later. However, at that time, the industrial revolution was going on. So that time, during the Paris Convention, to which of course India was not part, India was not even independent. There was no what we call the entity of India, and it was represented by British government. However, in the Paris Convention, the word industrial property first came in picture. What industrial properties? So basically it all started from the patent, to protect the industrial property, to protect the industrial designs, whatever the industries at that time are using, the machinery, the processes. They felt, the world at that time felt that we need to protect those properties, not just the immovable property, the property of the industry or the building, but the property or the product or the process developed by the industry, or uh, developed or created by the people who are working in the industry. Because people at that time also, people have started recreating it, redoing it, and to protect the right of the individual person who had the unique product at his disposal. He wanted to protect that product, and he wanted to protect the duplication of that product. So during that convention, uh, I guess 120 countries were part of the convention, and they unanimously said that, yeah, yes, we want to protect that those rights, or the protect those properties, and for which they created some rights in favor of the industrial property. Thereafter, there was a TRIPS convention, which is called, the full form is Trade Related Aspects of IPR, which is mainly for patents, trademark, and design. So to which India was the party, and not just party, but it was a convention, and they um discussed all the rights and properties of related to intellectual properties, and they started preserving patents, trademarks, and design for the industry. So in all, basically it started from the industrial revolution and started preserving the industrial designs prevalent at that time. Okay, so it is the beginning was 150 years back. However, to get the laws fixed, to get the laws codified, uh, at least India took 100 years after that. However, the laws were in place all around the world. People started developing laws, people started enacting laws, people started discussing about it. And after that, slowly and steadily, these laws came in place. Even in India, during British period, we had certain laws related to patents, copyrights, and trademarks. However, they were very raw, and they were not implemented that effectively because there was no awareness. People were not used to it. People used to think it is no, it is insignificant for them, and so on. After that, in 1886, the Berne Convention was there, and to which the India was the party, and they attended. India attended that convention, and it was only related to copyright. So the Paris Convention was related to patents, trademarks, and design. However, the Berne Convention was related only about the copyright, because copyrights were more intangible than the industrial property. So it was more intangible in nature compared to patents, trademark, and design. Therefore, it took some time to recognize those rights or those properties as well. To begin with our first intellectual property right, which is patent. Okay, we'll first start with the patent. And now at present, it is been governed, the India or the rights are governed by the Patents Act 1917. So it is not very old law. There was one law which was 1932 or 1930s law related to patents. However, it was not just raw, it was very inadequate. It was not giving any protection to any industrial design or industrial product or process. So there was need to abolish that law, repeal that law, and pass another bill for patent. So in 1970, the bill was passed in parliament, and the act was enacted. The meaning of patent. So what is patent? It is a document. It is document given to the product holder or the process provider. Okay, so it is a exclusive right granted to an invention which is a product or process. Patent is granted to a product which has been manufactured or which has been invented by a person, or it can be a process. It can be a process. For example, in pharmaceutical companies, the process of manufacturing certain tablets is way different from one tablet to another one. It is actually applicable in any industry. However, I am giving example of this pharmaceutical company for easier understanding, that when the process is different for each product, for each medicine, that process becomes the invention, and then the protection of that process is important or is relevant in larger sense. So apart from the end product, that is medicine, the process also needs to get protected. And when we apply for uh, protecting that process, and the document or the right we get is the patent. So the general definition is which patent is an exclusive right granted for an invention which is a product or process that provides in general a new way of doing something or offers a new technical solution to the problem. So if there is a uniqueness, there is a newness to the product or the process, then only the patent is granted. So under patent law, under patent acts, or all the intellectual property acts, they are self-sufficient. They have given all the rights or whatever the meaning, what patent is, what copyright is, what trademark is. Plus they have given how it can be protected, the machinery which is there to protect those rights, and if there is a breach, what are the remedies for it. So they are all inclusive, they are all uh, there are substantial plus procedural laws which are there in the intellectual property rights, and so they are very exhaustive. And if you start reading patent law or copyright or trademark act, then you will realize that everything is there. If you have been infringed with any patent or infringed with or there is a breach of your right, then you just need to go and search the act and start reading it, and you will understand what are the remedies available to you. So it is that simple. However, you need to know as a legal person to legality of the product or legality of the your rights. But if you start reading, it is very easy to understand. You will get to know many things, and you can implement those things in your product or process or whatever your property is. In patent, if you want to protect your product or process, you need to disclose the technical information, the unique information, distinctive information of your product to the authority to which you are applying for. Okay, so basically, you cannot keep your patent secret, or you cannot keep your product or process secret. So this is the main purpose of documenting your process or product, so that no one else can use that process or product. However, there is risk that if your patent gets rejected or gets expired, this information is available to public at large, and people can use it for their own disposal. Okay, so this is the patent. Patent is for the uh, is given normally in the field of science. So specifically, it is a technical process or the product which has been created by using scientific methods, or technical information is required in the product. That product or process is protected as a patent. It is normally granted for a period of limited period. All over the world, the term is different. However, now the WIPO is has given a term which is normally adopted by all the, or generally adopted by many countries, which is 20 years. So your patent, once it is disclosed and you are applied and it is granted, the patent is given for 20 years. So Indian law is to protect the inventor, so that the inventor can uh, monetarily gain from the product or process. So in India, the basic and main concept is to gain monetarily from the product or process. Okay, so this is a slight differentiation or distinction between international and Indian law. Of course, international law also protects the monetary gains or benefits which you derive from the Patent Act, but the main purpose or the definition itself in Indian patent law says that it is for the monetary benefit of the inventor. So the rights of inventor are protected for the gains. And after 20 years, of course, the inventor can renew it. uh, However, if, for example, after 20 years the patent is lapsed, right, and someone else uses your process to create or manufacture his own product, you cannot go and ask for the infringement or the breach of the patent, because your term has been lapsed. So you need to be very vigilant and keep on renewing your patent after 20 years again and again. Okay, only in that case your rights are being protected. Why is it so? Why it is given only for 20 years for limited period? Because even government do not want to restrict the information or whatever the discoveries made or inventions made in the scientific field to be restricted for perpetuity. If they do so, then there will be no improvement in the process, or there will not be there will be stagnancy in the technical discoveries or inventions. Okay, so basically this thought was behind before enacting this law, that stating that yes, you have been protected because there is uniqueness, your product is different. However, it is only granted for 20 years. um, of course, as uh, a- it is say similar to all the other laws, the patent act has been amended several times. For every act there are rules. For example, patent act, patent rules; copyright act, copyright rules; trademark act, trademark rules. So these the act gives the substantive rights to the person, inventor or the author. In case of copyright or trademark, the owner of the unit, or the logo, or the inventor of the, or the designer. That substantive rights is given in the act, and the rules gives you the execution part, that how you can implement those rights which are given by the act. So every, and the rules are amended, and have been amended like many several times from time to time, because of the advancement of technology, the procedures followed by the government or the authorities to grant the patent or other intellectual property rights uh, are are getting advanced. Therefore, the amendment in rules is also necessary. Uh, so, if there is infringement in the patent, or if someone still uses, if you have a patent, still someone uses your patent, or someone uses your process, same process to manufacture his own product, then in that case, what remedies you have, what you can do is, there are mostly in all the trademark, copyright, or other design act, they have similar remedies that you can. There are civil remedies, there are criminal remedies, and there are administrative remedies. So in civil remedies, person can go to court and ask for injunction. Injunction is, they can stop it. You must have heard about stay order. You get the stay order from the court to stop the production, to stop the process, to stop the use of the process, or the technique used in your product by someone else. So you can go to court and get the stay order on it. Then you can ask for loss of profit because of, or damages, in sense that because of this infringement, this duplication or using of my process, duplicate products are getting circulated in the market, and there are damages to my product. There are damages which I'm suffering because of circulation of duplicate product, or there is loss of profit because there was damage to my goodwill because the other product is getting circulated in the industry or in the market. Then there is a permanent injection which is similar, that for perpetuity no one can produce the product in that way. Okay, so this is patent act in brief, that is for the scientific invention, technical information which needs to be preserved and get patented, and it is granted for 20 years, and infringement of it is liable for civil remedies. Okay, then the next act is Trademark Act. Trademark Act was enacted. Of course, there was Trademark and Mercantile Mark Act 1932. Before this 1999 Act, which was like British era Act, and which was abolished or repealed, and this new Act came in picture. So the technical definition is a mark capable of being represented graphically, and which is capable of distinguishing the goods and services of one person from those of others, and may include shape of goods, other packaging, and combination of colors. So basically, trademark is given to, you must have seen like n number of trademarks all around your city or locality. Any uh, For example, Chitale. Chitale, if you are from all are from Pune, you must be heard of sweet sweet mart name Chitale. So they have a trademark on their name. Then there are like many other companies like Hindustan Petroleum or any other country, other companies which have their own trademarks, and they have registered it to protect it from getting used or getting duplicated by other person or getting impersonated by other person. Okay, so it is granted for the its distinctiveness. Okay, so what is distinctiveness? If you are using one product, for example a trademark which is not very distinctive, if you say for example, yes, uh, so trademark is given only if it is distinctive from the other other marks. So if you are taking a logo or mark which is similar to one product, to say for example Coca-Cola, if you are taking it, if it is similar to Coca-Cola, the trademark will not be granted to you. If so, the only condition is that it should be distinct. You cannot use common words. Like for dentist, you cannot use words like tooth, teeth, or similar to that. Or if it is a bakery, then you cannot use the word for trademark. Of course, you can use anything for your as a brand name. However, for getting the trademark, you there should be some distinctiveness. It should not be similar to other product, as well as it should not be very common, the words which are very common in our daily use. So if you see this granting of trademark is very discretionary on part of the authorities, to of which they are granting the trademark. So trademark is granted only when there is a distinctiveness in your product. Plus there are certain restrictions, like for example you cannot use word India, or you cannot use Hindustan or Bharat, because the use of word is not allowed as a getting trademark or copyrighted. Okay, so if you, once you, the word gets trademark, then no one else can use that word. Therefore the get the words like Hindustan, Bharat, India are not used or not allowed or restricted from getting trademark. You must have seen, see the next slide, that grant of trademark. If you apply, when you apply for any trademark or patent, there is a process that you apply for the product and you get it after like 6 months or 1 year. So during that period, if you must have seen on the mark, it is written as a TM or R. So when it is written TM, then it is when you are allowed to write TM when you have applied for the trademark. So till you get the trademark, you we will find that the TM is written on the product, uh, on the logo. However, once the trademark is granted, they just write R, which is registered. So when you see TM is the trademark which you are applied for and which is not still been not been granted. However, once it is granted, you will find they have written R. So now if you go around your locality, you will see or you will find this small difference, that when TM is written and when R is written. So TM is not granted, still not granted to that brand. However, when R is written, it is registered and you cannot duplicate it or you cannot use it in your product or in your mark. This trademark is granted only for 10 years and renewed for 10 years after that. So basically, as you can see, the all the intellectual property rights have been protected for limited period of time. So for patent, it was 20 years. Trademark, it is for 10 years. Of course, they can be renewed. So whoever is applying for the intellectual property rights need to be very vigilant that when your marks or your rights are getting expired, and once and immediately you need to file for another application for renewal of it. So that is very important. So if you fail to do so and someone infringes your right in between, then you cannot hold that person liable for the infringement. Okay. The infringement of registered trademark lead to legal suits and burden of proof of plaintiff is due to registration. So this means that if there is an infringement, you can initiate legal suit or civil suit against the infringer. However, the burden of proof is what? Who is going to prove that there is infringement is on someone who has filed a case, who is asking for the remedy. That is you, because your trademark has got infringed. In that case, if your trademark is registered, then it is very easy to prove that your there is infringement. However, if it is not registered, you are using some brand for like 20 years, but you are not registered it, then it becomes your duty to prove that your trademark is getting used by someone else without taking permission from you or without getting license from you for using that trademark. So, proving that this was the brand under which you have been operating for like 20 years, 10 years, 20 years, and now someone is using the same name, some same brand, and taking advantage of the name, developing his own business, then it is your duty to prove that how your brand is older and recognizable and well known in your locality or area. Okay, so you can take any name, you can use it without trademark for n number of times or n number of period. However, if it gets infringed, then it is very difficult to prove in court of law that your trademark is infringed, or not trademark, your brand or the name has been infringed, and you have been at loss due to use of that thing. Then there is a concept which is called as passing off. So even though we are aware of the trademarks, we are not very keen on getting trademarks, and people just start their businesses now with one name, and they flourish with that name, and still they don't find time to get the trademark registered. So you can franchise your business, you can pass it off, which is called as a passing off, concept of passing off. So when you are passing off, someone is passing off your name or your product or your brand as their own. That uh, that concept is called passing off, and which is very difficult to prove when your trademark is not registered. So passing off has is the another form of infringement, that your product is getting used in the same name and someone is, for example, impersonating your brand or impersonating you to sell those products. So all your goodwill, all your popularity is being used by someone else. So there are two things. One is using exact same brand or exact same thing, which is called as passing off, and using similar name or similar brand for their own gain is also infringement, because people, public at large, can get confused between two products and take the similar product in the name of first or the branded product. So therefore protecting your laws and your trademark is that important. Now there have been like thousands of cases, and now law is getting well established because of the cases and case laws. However, in before enactment of this law, this new law, there was no public were not aware of it. There was uh, mm, uh, there was what is the word I'm looking for, is there were people were sleeping over their rights, even though someone had the right, people were not aware of it, and they were even if there is infringement, people were not aware that we can go to court and ask for the remedy. However, after this 19 or after in this century, people are getting more and more aware of these rights, and people have started coming to the court and asking for their rights in this sense. We have seen the court is flourished with the land cases or immovable property cases. However, the cases involving intellectual property rights are very less. However, in last few years, they are increasing day by day because of the awareness created under this law. So even the as a public policy, people are getting aware of about this. Then the next law is copyright law. Copyright is granted for the expression of an idea, not just thought of idea. It is basically any work, any, for example, you have written one novel or a song or a screenplay or anything created under films is copyright, or anything created as a written piece of work, which is like novel, any poem or anything is a copyright. So if there is a you have created from your own intellect and which is unique and which can be based on similar ideas, but you have created your own product or your own work, then that product becomes copyrightable. So basically it is an expression of an idea and not just a thought or idea. So you must have seen in films that on one plot, on one idea, many films are created or many films are produced or directed. They are not infringing the copyright of others because the director, the producer are creating from their own intellect the different products. So even though the idea is same, idea it cannot be copyrighted. You can just copyright your work, whatever the work you have created based on that idea, you can copyright those ideas. So that property, that creation, that work, maybe novel or a film or a song or composition, that you can protect, that work can be protected by copyright. And how you have created different entity from the previous work, and it should be a original work. So if you have tried to copy something from another work and there is a substantial copy of the first product, then the product you have created, even though there is 25% of originality in your product, it cannot get copyright. Okay, so you need to prove that your product is original and is not copied from another rights. Unlike other rights, this copyright has multiple other rights as well. So multiple other rights like reproduction, you can reproduce your work again and again. If you have a novel, you can reproduce your novel again and again. If there is a song, you can compose it, or you can uh, publish it again and again, like cassettes and CDs. And there are some neighboring rights, like you can, someone can perform on it, you can perform on it, or you can broadcast it. So these are other multiple rights, including neighboring rights. So once a product is created or once a work of artistic nature is created, you can have different rights or different ideas or acts based on that product. For example, if you write a novel can be made into a play or on a film or just a short film, or just someone can just narrate your novel. So these rights, these multiple rights, neighboring rights are created once one product is one copyright work is created. And as there are thousands of rights created because of one copyrighted product, it is granted for the 60 years, which is the highest. So once the product is published, the work is published, then it is protected for 60 years. So for example, if I write a novel and if I publish it tomorrow, then I will get the copyright for 60 years from its publication. You don't need to register the copyright. However, if you get it registered, it is easier for implementation. However, publication in itself gives you the copyright. Okay, so you don't need to register the your work. Unlike patent and trademark, you need to register those products or those things. However, under Copyright Act, once it is published, you are protected for the 60 years. And there, as I mentioned, that there are broadcasting rights or performers right, that someone is performing on it. You can grant those rights for to another person on license, which are protected for 25 years. So for example, you are the lyricist and you have written a song. So as you have written a song and you have published that song, then you get the copyright for 60 years. If you give license to some performer, if you give to singer, then he will have the performance right for 25 years, because that right is again unique for him for the performer, and he gets that right for 25 years. The broadcaster gets the right for 25 years. So these are the rights which have been created because of the copyright. This copyright thing is the most complex intellectual property in the complete or whole intellectual property rights. Again, the yes, and unlike trademark and patent, when you register for patent, the person inventor is the patent holder and he is the exclusive owner of that property. Similarly, trademark. However, in copyright, once copyrighted is created, as there are multiple rights, there is no monopoly uh, uh, of the creator or the author on that product, because creativity has no boundaries and it can be recreated in different ways. So for example, in if you write a song and if it gets remixed, the copyright for that remix will be given to the remixer, the other person. However, for that also he needs to take permission and give the loyalty or royalty to the first creator, which is the first author of the lyricist of that song. So even if when you play, for example, any film song or any song sung by Lata Mangeshkar or any person or written by Samir or anything, then you need to get, under this law you need to take permission from the composer, lyricist and singer before singing that song. It may be in private performances or in public performances, you need to take the permission. So if say for example, lyricist comes to becomes aware of your performance in say private ceremony, some private ceremony, he can take action against you. He can take action against your performance because you are not taken permission from him. However, it is way impossible to take permission for each and every time for any private ceremony or private program. But under this law, if mm, uh, the original author wants to take an action, he can take the action. This is what law says. Then similar to other part, the remedies are civil, criminal and administrative. So civil, we have seen that you can ask for injunction, you can ask for compensation and damages, which is monetary reliefs. And criminal is criminal is when a person can get into prison. So if the punishment is provided under the act, it is called criminal remedy. So under Copyright Act, we have a criminal provision uh, for 2 years, maximum 2 years, a person can get imprisoned. And administrative is similar to civil, is take the injunction and stop him from using that, reproducing that work uh, in the future. Next is design. The design act is a new and original feature of act. Basically, it is to preserve the design. As you can see, there are like 4 or 5 products which I have given that they are unique in nature. The clock, or the crocs, or the packaging, or any design of bottle, or any manufacturing like mixer, or chair, for any furniture, that design in itself, not the product, just the design, you can get the design protected, and that comes under Design Act 2000. So it should be a new and original product, and new and original shape should be there. Again, if you have not registered the design, it is very difficult to get the remedy, to get it protected from, or get the protection from the infringer. And therefore there is a process, design process, registration process. Of course it is similar to trademark and patent. And Copyright Act, you know, need not get it registered. However, if you want to get it registered, it is similar to this all the other provisions. So filing of the application, then the authority examine the report. So you have to file the application with all the papers, that this is my design, how I have created it, and how it is different from other products, how it is unique and appealable to the eye. So everything you have to give all the documentation related to the product. Then there is a controller respond to your application, that if there is some there needs to be done, or some other papers are required, he responds with the requirements, and then the design is published for the public at large, and then the registration process is completed. So all this registration process, once they get registered, your product, your process, if it is patent, then they get published for the public at large. So it is no more secret. So this can be advantage, or this can be disadvantage as well, because if the process is not disclosed, you cannot fight and say that the process used by the other person is similar to my process. So your process is first published, and then someone is using the similar process thereafter, then it is easier to fight for it. Then who, when, where, and how long any person claiming to be proprietor of any new original design may apply for registration. Before making the design available to the public, as not novel design cannot given. So there should be originality to the design. It should be novel in itself, and then only the registration is the registration process is accepted or admitted. In India, there are design offices in Kolkata, Delhi, and Mumbai and Chennai. Basically, not all cities, not all state have all the offices and everything at place. So machinery is still getting established under these acts, and you get protection for. You need to apply for it and get it registered. So again, design is protected for 15 years. So trademark, patent, and design can go hand in hand. So if you're you are protecting your product, for again I'm giving example of pharmaceutical company, you can protect your product, which is tablet. You can protect the process by which you are manufacturing that tablet, and you can also protect the design of the tablet, or design of the packaging, or design of the logo. That in that case, you are protecting everything. Plus the company, pharmaceutical company, is protecting his brand or his mark as a trademark. So one company can have multiple things and all the intellectual properties based in one product, and the company can protect their intellectual property by availing all the registration processes under this intellectual property rights. So the remedies available for design are 50, some not exceeding 50,000 rupees, and the contractual dates. So both they can apply for. Then the recovery of damages, similar, that there is a damage to the reputation or the damage to the not just reputation, goodwill, and there is damage to the product as well because of the use of the similar process by another person. Then there is injunction against the reputation. For the future non-repetition, person can ask for remedy. Okay, so this is design. And the last is the geographical indication. So geographical indication is something uh, is very unique and is very limited in source. So for example, the best example is Kolhapuri chappals. They are from the region Kolhapur, and Kolhapur is protecting their design. It is mostly for the design. Okay, so they are protecting the design of chappals as Kolhapuri chappals. So no one can reproduce it, no one can infringe it, and they have been given to the region itself, that they are from Kolhapur, and Kolhapur is having the unique and geographical indications for them. Again, it is for the 10 years. Similar to Kolhapuri chappals, there are many other examples. You will find it in India itself, plus internationally, there are many products which are being protected as geographical indications. So there is concept. It is not just for product. It can be for the process as well. So everything, if it comes from the region, it is protected. In our day-to-day life, we say that yes, the chappals are from Kolhapur. Then this product, the paithani is from Yeola or Paithan. So likewise, we have many products which are region centric. So in that case, the geographical indication is given. So apart from design or apart from brand, the indication in itself is also protected, that it is from that geography, and that geography had the monopoly over that product, and it is for them. This act, this geographical indication, is not just for the civil remedy, and the main remedy is the criminal remedy, which is imprisonment not exceeding 6 months. So it is granted for 10 years, and it is the only remedy given is imprisonment not exceeding 6 months. Then there is franchising. If you have IP, intellectual property, you have the know-how, then you can develop your own models, business models, but training, by giving training and support, and you can take the fee, and the franchise is given. So best examples I have given, which I came across. First is Chitale Bandhu Mithai Wale. So you have a franchisor, which is the owner of the brand or the trademark. Then you are creating the product. You are getting the product which is trademark, and then you are giving franchise to someone, and the product is getting given to the customer. Then there is another example is Yevle Amrutatulya. You must have seen that Yevle Amrutatulya all around our localities. What do they do is the franchisor is giving the model, the business model itself. They are not selling the product, they are giving the business model, that they are giving everything, all the packages, the tea, the sugar, the quantity, everything is been provided to them. They just need to run it as per their instructions. In Chitale Bandhu, they are giving the products. They are the manufacturer is the franchisor, and they are giving the product as a franchisee. So they are not transferring the IP. They are just giving the license to sell those products. Here in Yevle Amrita Tulya, they are giving half of the IP and half of the product. In Javed Habib Haircut Salon, they are imparting their knowledge, their intellectual property to other person. Okay, so how haircut, they are giving training to their haircutting like the trainers about the haircut, the techniques used for getting the certain haircut, which is unique for the Javed Habib salon. So they are imparting their knowledge, they are giving their IP, and that franchisee is creating the product. That franchisee is creating the product based on the IP imparted by the franchisor, and the product is getting to the customer. I hope you have understood the different franchises which are operated in the field. Okay, so there are these three franchises are there based on the IP which one can create. Then what are the advantages of the intellectual property? Ability to have a competitive edge over other similar business. So they have a competitive edge, which is obvious, no need for the explanation. Then it enhances the goodwill. It enhances the value of the company, or the, even if it is a sole proprietor, the person. Then it helps you market your company's products and services. Very easy to understand. You can more easily obtain finances for your business. Again, if the goodwill is created, if it is improved, then the getting finance is very easy. Then you get the greater export opportunities. And lastly, mortgaging your product or mortgaging your brand becomes very easy. Or even you can license your product or the brand, and you can gain monetarily. There are certain disadvantages to the IP as well. As it is a long process, you need to fight for it. Once you start, you if you start registration for patent, and if it gets rejected, still you are opening all your processes, all your secrets in the product. So it gets it becomes available to the public at large, and you are not your patent is rejected, then it becomes hassle for you to defend your product. Then in copyrights, there are chances of pirating. Okay, so it is very common, like films get pirated or books get pirated. Like in 2 weeks back, a person, someone, the Xerox wala was selling the product, selling the book, all the Xerox of the book, uh, the complete book, which was photocopied, he was selling it for like 50 70 rupees. So the publication company of the book approached the court, and now court in the court case is pending. However, there is an infringement of copyright in this sense, because they are pirating or they are reproducing without their consent. Then it IP rights are not absolute. Their quality can get reduced. Okay, so this is the disadvantages of IP as well. So even if you have certain rights, there are certain disadvantages to the intellectual property rights as well. Okay, so lastly, I'm going to tell you very interesting facts about the uh, TK, which is traditional knowledge of India. So traditional knowledge of India, which we are using, for example, we are using turmeric, which has a healing properties, and we are using it for thousands of years. And it has been mentioned in our Ayurveda, in our Vedas, and other literary works about these products. Okay, not just turmeric, but other Ayurvedic ingredients as well. So we were not aware of the fact that I've written that 1995 United States granted patent to University of Mississippi Medical Center for wounding healing property for the turmeric. Same product, turmeric, they granted patent for the turmeric. Okay, the product based on the turmeric, of course. An exclusive right has been granted to sell and distribute that product. So when we came to know, the India came to know about this development, the Indian Council for Scientific and Industrial Research had objected to patent granted and provided documented evidence uh, located in different languages, namely Sanskrit, Urdu, and Hindi. And the United States revoked the patent granted to the University of Mississippi. So this was the first incident when we came to know that uh, the countries abroad or the institutes abroad are getting these products patented for in their name. So once the patent is granted, it becomes very difficult to revoke it. There is a there is a small difference between our law and like United States law or the law patent law of other countries, that the process in other countries is very secretive, and once the product gets patented, then only the patent is released. However, unlike India, once we apply for a patent, then the process and the public patent is published before granting patent, so that person who is having claim on that patent can come and object it. However, in United States, it's completely opposite. So in United States at present, also people are trying to get the patents based on the products available in nature and which we are using as our traditional knowledge for years together, for thousands of years. So this in 1995, India became aware of all these things and started creating library for preserving our traditional knowledge. So they established TKDL, which is Traditional Knowledge Digital Library, and a database currently containing codified published literature from Indian systems of medicine. So they have started creating this library, and they have started preserving our traditional knowledge, so that if a patent is granted anywhere else in the world, we can we will have database, we will have the sources to protect our product or our knowledge getting patented in other countries. So basically, this was the first case, which was for the turmeric, and we snatched that from US and we protected it for the India. Similar to basmati rice was also, the similar rice was getting patented in US in the name of Kasmati or some other name. However, again, Indian Council went to US and they protected basmati rice against that. Similar to Kolhapuri chappals, and there are many products. Even um, other products are getting tested and getting involved, and India is constantly on check if the products are getting patented or not. Yeah. So this is about the traditional knowledge, and this is now become a new form of intellectual property. Even though there is no inventor, one inventor or new inventor in India right at present, as we are using this knowledge, traditional knowledge for long, it has become the traditional or intellectual property of India. So we are trying to, the India is trying to protect it from the foreign infringement. Okay. So I guess we have come to an end to our session about intellectual property. I hope you have understood and what I was trying to tell you by giving examples also. So if you have any questions or anything you have concerns, you can ask me.
Yes, students, if you have any query, please ask. Yes, any query related to IPR, please go ahead.
Hello.
Yes.
Hello, ma'am. Good afternoon.
Yes.
My name is Anurag. Ma'am, I would like to ask you one question related to IPL. Like, how will you explain the exclusive right which are taken by Tata? Hello.
Tata, I'm not aware of it. Tata, they have taken
The rights, the
rights taken by
the
Tata of
to like they have before the name of IPL there is one name of Tata. So how will you explain this in there? Is this a intellectual property or something else?
no, they are. I'm actually, I'm sorry, but I'm not aware of this thing that Tata has taken IPL or whatever. If they are writing the name, for example, Tata IPL, they are
Hmm.
the sponsor of it. So they are. There is no infringement of, or there is no product of intellectual property. They are
Okay.
using the name to show that they are the financer or the
The principal
they are
sponsor.
having or they are sponsoring it. So there is no infringement of intellectual property in that sense. And they must have contracted with the IPL authority about the same. So there is no infringement. Even if there is, they
Hmm.
are using IPL on their name or their on their site to market it, then they must have taken permission or license for it from the authority.
Oh, okay, ma'am. Thank you so much.
Okay.
Yes, anyone else? Okay. So, on behalf of Matrix School of Management Studies, I, Dr. Anand Padare, thank our guest of honor, Advocate Amruta Mendle Madam, for a wonderful session on intellectual property rights. During the session, Madam made the students aware of various rules and regulations related to patents, copyrights, trademark, and design. I'm sure students have now a better understanding of intellectual property rights. Thank you, Madam. Once again, thank you.
Thank you so much. Thank you,
Thank you,
students,
Madam.
for patiently listening to me. Yeah, thank you so much.
Thank you. Thank you, Madam. Thank you very much. Yes, students, we will be very shortly, we will be posting the feedback form on the group. Please fill the feedback form immediately. Mohit sir. Hello, Mohit sir.
Yes, sir. Yes, sir.
Hello.
Yes,
Ha,
sir.
Mohit sir.
Yes, sir.
Please share the feedback form in the chat box.
Yes, sir. I already posted.
Okay, thank you. Thank you. So students, please fill it immediately. We will keep the link open for next 5 minutes. So fill it immediately.
Okay, sir.